Welcome to the Virtual Center for the Study of the United States Constitution with your host, Dr. Bill O'Brien.
Good afternoon. This is Bill O'Brien, and it is a pleasure to be with you on this beautiful Tuesday afternoon. It's the 16th day of July, and we welcome you to the Virtual Center for the Study of the U.S. Constitution. I am Bill O'Brien, and I look forward to a couple of hours of conversation related to the Constitution, sometimes more directly than others, but always the Constitution is the theme. I invite you to participate actively in the program. First of all, I want to thank you for tuning in to the Horn and to the Virtual Center. And I want to invite you to participate actively in our program. If you are inclined to comment, offer your suggestions, your additions, your corrections, whatever, different points of view that you might have on our subject, on our topic, then by all means. When I say I would love to hear from you, of course that's true. But the fact of the matter is everybody out there would appreciate hearing from you too. Part of what makes this whole operation go, and I don't mean just the Virtual Center, but I mean the Head-On Radio Network itself, is the opportunity for conversation. I know Bob Kincaid refers to it all the time as the conversation network, and we want it to be that. It is not intended to be a monologue. It is not intended to be in anywhere dogmatic or demagogic. It's not designed to put forth a point of view. It is rather to throw out, obviously I can't help it. Sometimes, most of the time what I say is going to be my point of view. But I throw it out for discussion and for analysis and for reflection. I do not throw it out as a work that is completed, but rather a work that is in progress. I think whenever we reach the point where that's not true, when we admit to ourselves and to others that we do not choose to learn anymore, that whatever learning we were going to do in our lifetime has in fact been completed, then I think it's time to turn off the network and hang up, and I mean that literally as well as figuratively. So we do respect and welcome your point of view, and not only that, but the other people that tune in respect and look forward to it, and to be very honest with you, kind of have a right to it as well. So I invite you to give us a call. We have a number, area code 304-658-3333. That's 304-658-3333. That will get you into our studios, and we'll get you directly on the air. We've been trying to make some corrections in technology. We were, just before we went on the air today, in fact, we were commenting that we think I don't know what we did. We prayed over it, kicked it, whatever we did. But we seem to have a connection today that is more powerful than correct connections that we've had in the past. Whether that signals some sort of victory, or whether it in fact is the silence before the fall. We don't quite know that. But we do encourage you to participate and to offer your opinions and ideas and reactions to what I think is some pretty controversial stuff at times. Today I want to continue on a train of thought that we began several days ago on the idea of co-determination. It is a spin-off from the very wonderful email that we received from Sweden a couple of weeks ago from Scott, one of our regular Head-On Radio listeners, and he was kind enough to put down in email form his thinking about the Constitution as it compares with the social democracies of Western and Northern Europe, and more specifically with the Swedish democracy within which he currently lives. And the insight is incredible. The questions he raises, the observations he makes are very, very healthy and very, very important. To be honest with you, and I don't want to overblow because I don't want Scott to feel bad. He listens to these programs. If not live, he listens to them, on archive, on an iPod of some sort. But I don't want to, embarrass him in any way. But the fact that we would get that kind of perspective from the other side of the ocean seems to me to be very significant, because it fulfills, in many ways, the potential of the Internet. It gives us an opportunity to have conversation that crosses borders as well as oceans. And I think the conversation that we are having is a conversation which is very, very necessary to have. I'm hoping today, for example, that I can share with you and make that point, because I believe very strongly that it's true. I really believe that in the marketplace of ideas, in the world of conversation, of political and economic and social conversation that we are engaged in today, I believe, I've said this many times, I know you've heard it before, I don't mean to repeat myself or to beat a dead horse. But the fact of the matter is, I listen frequently to different points of view. I try to do as much reading in a variety of different areas and venues as I can. And my observation about the Head On Radio Network has been nothing but strengthened in previous weeks and months. And that is that this conversation has to continue. This is a point of view, a conversation that isn't available in other places. It's very, very important that it be out there. The challenge, and I think all of us recognize this, the challenge is to get people listening to it who don't regularly tune in to the Head On Radio Network or to a program like the Virtual Center. In order for the free exchange of ideas in the free marketplace to happen, then that means that we have to overcome this tendency to go to those sources, to those places where we are most comfortable with the point of view or the spin that comes from it. And again, I mean this very sincerely. There is progressive broadcasting out there. There's a lot of progressive broadcasting, a lot of, fortunately, a lot of progressive voices out there. But I would suggest to you, and this is in my own personal case, that in many cases we are into a situation where we are almost compelled to outshow the other guy, if that makes sense. And I don't believe that that's conducive to reflection or conversation or anything else. So I believe what has to happen is real reflection. And I believe for real reflection to happen, there needs to be a willingness to seriously consider, to take seriously points of view that don't agree with our own, and not look for ways to shoot holes in them or to undercut them or to weaken the foundation of them or to try to argue them down or demean them. I mean to seriously consider the perspectives and the points of view that are out there in the marketplace. I think we can all learn from that. In fact, and this is kind of a subtle way of leading into our theme, which at least at the beginning is going to be co-determination. But I believe that part of the issues related to the challenge in management labor relations today within the United States and within the developed world itself is this willingness to reflect and to think rather than to react viscerally. Maybe that's the appropriate word, to react from our gut, so to speak, to react without thinking, to react in ways that we have been programmed to do or that we are used to or that we are most comfortable with. I think we need to begin to listen to the other guy. And I think before we, if we don't begin to do that very soon, I think we're going to be in more trouble as a country, as a civilization, than we are currently. I really believe that. And again, you can focus on religion, you can focus on economics, you can focus on society, you can focus on the job market, you can focus on the economy, you can focus on labor management relations, you can focus on the whole issue of diversity, cultural and racial diversity. You can focus, if you want, on the very controversial Florida court decision that was reached this week in the death of Trayvon Martin. I don't care where you go, but the more you listen and the more you hear what people have to say, the more you realize that there's a gap, there's a hole here, there's something missing, there's some element of communication that's not happening. And I think first of all, that's the issue that we need to make clear. But even beyond that, that's the issue that we have to basically bring to the table and provide some credibility for, so that people begin to take it seriously, begin to look for that element of communication that's missing, and find a way to provide it. It's not negotiation, it's not compromise, it's not middle of the road, it's not ideological neutrality. It's not, whatever you want to call it, depending on what side of the, what side of the political spectrum you might fall on or sit on. That's not really what we're talking about here. For example, I would be remiss if I didn't at least make mention of the Zimmerman decision this weekend. Everybody else is is talking about it over and over and over again, more and more and more, and the extent to which race was a factor. The jury declined. I heard just yesterday that CNN did an interview with one of the jurors who was anonymous, and of course she denied, as one would expect she would, that race played any part in the decision. I mentioned a few moments ago that in our conversation there seems to be there's something about our ability to communicate or not communicate that's missing. And I think there's an example of it right there. Because, was race a factor in the decision, and then the people that made it say no, it wasn't. It seems to me that there are so many factors associated with race surrounding that particular decision that I think it makes the issue so much more complex. But I think somehow we have to find our way through it. Because the fact of the matter is that decision didn't satisfy anybody except, certain people. And the fact of the matter is the people that are most satisfied with the decision don't provide a solution to our concerns. In effect, the reason they are most considered is because it fits into their frame of reference, their political and ideological frame of reference. And it seems to me that what we do with an issue like this needs to be deeper. And what I mean is the issue of race. I'm not going to get into the decision. I don't want to spend 2 hours on the decision. I think that anytime you want to spend 2 hours on that decision, you can just turn on the radio, turn on the internet, turn on cable television, go to CNN, go to MSNBC, go to Fox, go to wherever, and you'll hear the appropriate, the predictable spin, so to speak. But in the process, you'll get a lot of information and a lot of along with that spin. And I recognize, because this is the Head On Radio Network, that we're dealing with people who will recognize spin, who can recognize spin and see through it and are able to separate spin from fact and from important pieces of information. One of the things that struck me in this decision were the comments after the decision was made by the different sides, both the prosecution and the defense of Zimmerman. And there's an awful lot of questions about the weakness of the prosecution. They neglected to tell a story. They went along and allowed the defense to tell a story without challenging that story, which meant that that story in everybody's mind became the story, et cetera, et cetera, et cetera, and whether in fact that was a mistake. And we've heard that the prosecution was, didn't seem to have an issue, didn't seem to have a focus, didn't seem to have the enthusiasm necessary, blah, 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 on and on and on. And I'm not going to, I don't know that I can add anything to that. But after the decision was over, one of the defense attorneys, Mark O'Mara, I believe is his name, addressed the issue of race. And basically what he addressed was the issue of what if. What if Trayvon Martin was, what if the racial situation was different? What if Zimmerman was black, the shooter was black, and what if the victim was white? Would the decision have been different? And the comment that was made by the defense attorney, Mark O'Mara, was a very, was I think a significant one. And I'm not taking issue with his comment. From where he comes, where he sits, that it fits right into his frame of reference. But his comment was, if the shooter was black, race would have played an issue in this because the case wouldn't even been brought to trial. And I've heard a couple of people make reference to that comment. And the more I've thought about that comment, the more concerned I am, because I think therein lies the issue of race. But it's subtle, and it's there. And the first thing that occurred to me when I heard that was basically the attorneys for the defense from the beginning of this case were convinced that if the racial situation were reversed, there wouldn't even have been a case. In other words, falling into the old idea that African Americans in American society get a pass on things on some things like this, that there's so much pressure from the left that the case probably wouldn't even been brought. Now, obviously, as defense attorneys, these attorneys are not neutral. Their job is to not lay out the facts. Their job is to defend their client. Understandably, even the opponents admit that they did a good job doing that. That's not my point. My point is, and I'm not going to do it, but my point is, if you went back through the entire trial, all the video transcripts of the trial, would there be any evidence during the testimony, whoever's testimony it would be, from either Mark O'Mara or from the other defense attorneys, the other people on his team, that reinforced that? Because if there was any element of that on the jury, if there was any sense at all on the jury of agreement with that point of view, and if that point of view was expressed or even inferred in the course of presenting the case or cross-examining the prosecution's witnesses or whatever, then in a sense it would have been a subtle signal to the jury that the defense team recognized what they were doing. It would have almost been a psychological wink of sorts. When I say wink, I mean W-I-N-K, if you know what I mean, where there would be no verbal communication necessary, but the connection and the communication would have been made. You know, and so in a sense, if there was any evidence in questions or the way the questions were phrased or the way the cross-examination was done or the way the evidence was portrayed or anything else, if there was ever any, not just clear evidence, but even inference that this particular assumption concerning race was in that room when the questions were being raised, and if there was any evidence at all that the jury could have picked up on it, then race could have been, would have been a factor in this decision, even if the people that made the decision didn't recognize it. And that's what makes race in this country so insidious. This is a common phrase, and I don't mean to play lightly with this. But what makes race in this society so insidious is that, quote, the best people sometimes practice it, unquote. And what I mean by that is race is so negative in our society. Just think of Paula Deen and that issue. It's so explosive that nobody really knows how to deal with it. The only thing everybody knows is you better not deal with it because you can't do anything but lose. The discussion that needs to happen in order to begin to address the issues, the subtleties, the real subtle issues of racism in this society is yet to happen. And the reason is because nobody who has any skin in the game at all is willing to participate in that kind of a discussion. Because the liability of getting yourself into trouble is so strong. The companies that bailed out on Paula Deen, I'm not going to get into the details of all of them, the Food Network and Walmart and I don't know who else is involved. But the fact of the matter is that they all bailed on Paula Deen. Now, we have to believe, I don't think anybody in their right mind would be naive enough to believe that these companies, every one of these organizations, was so moral and so straight of the line and so opposed to racism and all the rest of it that they are doing this because their position, their desire to eliminate race from American society is so strong that they found everything she said offensive. It's very obvious that their concern is that if there's a lot of negativism towards Paula Deen, it's going to be reflected in the companies that sponsor her. And therefore the companies could suffer damage as a result of what Paula Deen said from the people, from the American consumer. And so therefore, in order to make sure that none of that happened, they severed the connection with, they literally threw Paula Deen under the bus. I'm not defending Paula Deen. I'm not defending the issues of race at all. What I am suggesting is that it is so explosive. It is so explosive that in this society, people are getting fired. They're losing their programs. They're losing their TV shows. They're losing their radio broadcasts. In other words, it's if you remember your Harry Potter. It's the name that shall never be spoken. It is so volatile, so explosive that nobody even touches it. And the fact of the matter is, it continues to go unaddressed. The communication doesn't happen, and I would suggest that the problems can't be addressed that way. And I mean this very sincerely because, and I hope I wasn't more subtle, or I hope I wasn't talking about something in this particular case, the Zimmerman case, that was so subtle or so vague that I didn't make my point clear. I'm not saying that the attorney in question, Mark O'Mara, is a racist. I'm not saying that the jury is racist. I don't have the right to say that. I don't have a right to say that. But what I do have a right to say is that the issue of race itself is so explosive, so politically explosive, as well as socially, economically, and humanly explosive, that nobody wants to touch it. And everybody's trying to get away with hands clean when the issue comes up. So, you know, whether in fact the things that Paula Deen said were offensive enough to African Americans as to warrant her dismissal, that's something that she's going to have to deal with, and I'm sure she is with her attorneys and everything else. But the fact that everybody is who is associated with her kind of make sure that they draw the line and make sure that there's serious distance between them and her, I think is very significant, because she's toxic now. And the mere fact that we're talking about an economy that is based on on consumer positivism and all of that. By definition, if you're selling a product in the marketplace, you can't afford any semblance of negativism at all. So therefore, you have to appear to be holier than thou. You have to be cleaner than clean. And that means you almost have to sever the connection with somebody who has allowed herself or himself to become toxic. And I think that toxicity is the issue, because it makes it so difficult to have the conversation or to begin to talk about the things that make the conversation real. I mean, I have heard so many things about Trayvon Martin, so much about Trayvon Martin and about Zimmerman, and he was not a policeman, but he was a wannabe policeman, and he was carrying a weapon, and he didn't have a right to trail this guy, and he didn't have a right to do this, and he was told by the police to back off, and he didn't do it. And he did all of these things. And what he did was set up a situation which brought the Florida Stand Your Ground law into play. The Florida Stand Your Ground law, if that becomes the issue around which the decision has to be made, then it stands to reason that the jury couldn't find any other way. So, in a sense, what I'm suggesting is maybe the Stand Your Ground law is the issue here. Maybe the context within which this whole thing unfolded is the issue. Because nobody would have a problem with something called the Stand Your Ground law if everybody believed that issues of class and race and ethnicity and religion were never going to come into play in the day-to-day implementation of that law. But the reality is everybody knows that that's not true. Everybody knows that there are certain stereotypical positions and attitudes on certain groups of people that come into play. And so to pretend that the Stand Your Ground law in Florida exists in a vacuum and that none of this other contextual stuff comes into play at all, that's the real issue. And that's what you can't cut. That's what's become so difficult to cut your way through all of that. So, my sense is there's serious conversation necessary on a number of issues, and this one happens to be the most topical one because it's the one that the nation has lived with for the last several weeks. And I'm not trying to pretend that I'm smart enough or sharp enough or perceptive enough to bring anything new to the table. I've heard some brilliant discussions on this particular decision from both sides. I really have. And the complexities are incredible. And, you know, this sounds a little bit naive. But you almost wish that the case could start after the discussions and the points of view have been made. There's so much on the table now. There's many different perspectives on the table. There are so many issues surrounding the case that have been raised. There are so many factors to consider. That you could say that only now is the nation ready to take on this case. But that's not the way our jury system worked. Our jury system, by definition, operates in just the opposite direction from that. The jury is not allowed to take into consideration any of these other things. The jury is asked to take into consideration the facts of the case as they unfolded and as they were portrayed by the two sides. And the law, the Florida law, that basically gave Zimmerman the right to stand his ground. Because there's absolutely no question that the law did give him the right to do that. But if you don't consider all the factors surrounding and leading up to that, then you really, it seems to me, missing the point. You're operating on the naive assumption that the law exists in a vacuum. And it's entirely possible to find, in this case, 6 people, totally neutral people, who didn't know about all the contextual stuff associated with it, and were able to basically isolate themselves, go into isolation, discuss the facts, discuss the law, and come up with a decision that, theoretically, at least the way our justice system works, is the avenue to truth. I mean, if you think about it, I've done this for years with classes, especially political science, government classes, about the legal system and about, the right to jury trial and some of the Supreme Court decisions associated with it in terms of the right to an attorney and the right to face your accuser and all these other things. If you think about our justice system, it's based on the idea that if you find a certain number of people, the big juries, it's 12. In this case, it was 6. But you find a group of neutral people who haven't prejudged the case and who are not carrying with them so much obviously biased baggage that it's going to indicate what the decision is going to be no matter what the facts say. In other words, if you can find 12 people that are going to allow their decision to be based on the facts as presented in the case and not allow other factors to come into play, the assumption is if you get enough of them together in the same room, and then you have the best argument for the defense and the best argument for the prosecution. In other words, you have the very best arguments on either side presented. Then the assumption is that in the normal case, 12 normal people who are objective and haven't prejudged the case and who are not allowing their decision to be affected by prejudices or stereotypes or any of that other stuff. And all they do is hear the evidence, the pro and the con on either side. Then if they go off to a room together, and if they can reach consensus, then our justice system is based on the idea that for purposes of due process in our society, that is truth. That is the avenue to truth. And, I think that those are the assumptions on which the justice system functions, on which the justice system is based. And, of course, the key is that the citizenry, the general population, has to have faith in that system. And so when you get a case like the Zimmerman case, which is so controversial and raises so many issues of injustice and racial prejudice and all the rest of it, the real issue is not, the decision obviously is important in terms of the people involved. But in the long term, the big picture is faith in the justice system itself. And, you know, I've heard some people, and the name that comes to mind, there are others, but the name that I'm most familiar with is Barry Scheck. And Barry Scheck is often called in as an expert in these kind of cases. And again, he is an authority on the justice system promoting justice. And it's absolutely incredibly insightful and revealing to hear him talk about what happens in our legal system. For example, I heard just maybe yesterday, within the last 48 hours, I heard him make the case about plea bargaining, talk about plea bargaining. And his whole point was our entire system is based on the idea of being able to plea bargain in order to avoid going the full length in these trials. If there was no more plea bargaining in our justice system, if everybody involved in a case like this went to trial to the end, the whole system would break down. It would implode internally because there's no way it could handle it. So the only way that the system remains anywhere near efficient, and everybody knows it's not, there's too much time that goes on oftentimes between the crime and the case on the crime. But the fact of the matter is, the only way that you can talk about any sense of efficiency at all is based on the assumption that there's enough plea bargaining going on to pull enough of these cases off the table that it makes it possible for the system to run its course on the others, on most of the others. But his point is that the plea bargaining system itself has been affected by so many outside tangential issues. For example, the inclination of legislators, this goes all the way back to the 1980s, to the Ronald Reagan era, and the idea of really coming down hard on criminals and on crime. State legislatures began to pass legislation mandating minimum sentences for certain crimes. And what that meant was all flexibility was being taken out of the hands of the courts, of the judges, of the attorneys associated, etc. The ability to decide, the ability to determine justice in a particular case, in many cases has been taken out of the hands of juries, out of the hands of the judges, and has been taken over by elected representatives, by state legislatures, who say that if you are guilty of this crime, this must be the minimum sentence. And if you were guilty of the same crime a second time or a third time, then this must be the appropriate result. And so once if a case comes up against that kind of legislation, then plea bargaining, claiming, being willing to plead guilty to something less than the ultimate offense is the only way to avoid the mandatory sentence. So oftentimes, and this is what Barry Scheck's point was, and I just think it's fascinating, his point is that there are a lot of innocent people sitting in jail who have pled guilty to things because they were operating within a context of a state legislature who had already mandated the sentence for them. And if they let the trial go to fruition, if they let the string run itself out, so to speak, then they were looking at the legislature's mandated sentence, which probably was a lot worse than the sentence they got with the plea bargain. So what that meant was that some attorneys, in the best interest of their clients, are recommending that innocent people plead guilty in order to not allow the mandated sentence for that particular crime to come into play. So state legislatures have allowed political public opinion, have allowed political context, their idea to appear to their constituents to be hard on crime and hard on criminals and more sympathetic to the victims and all the rest of it, has led them to support legislation which really materially alters the legal system. For many people, it's making justice unattainable in our society. But there's so much of it that's going on that the question, it's beyond us. And so what I'm talking about here is the issue of context. As a historian, I do this all the time because I think the issue of context is incredibly important. I don't think that you can understand history unless you understand context. I don't think that you can understand laws if you look at the particular language of a law and assume that that law is passed in a vacuum, that emerges in a vacuum. Laws never emerge in vacuums. Laws obviously are proposed by, drafted by people in order to accomplish certain things. And frequently, laws are passed by some people to control or regulate the behavior of other people. And who's going to win and who's going to lose by a particular law being applied in a particular case is oftentimes, if not only oftentimes, is always an important consideration in understanding the context and the intent which led to the creation of the law in the first place. I think one of the things that we have to make students aware of, for example, is that law, by definition, is never neutral. And that's the whole idea. It is designed for a purpose. Law is designed to accomplish something for somebody at the expense of somebody else. And it leads logically to the next step, which is that if that's the context within which laws are going to be drafted, written, passed, whatever, designed, then making sure that you have enough political clout to get your particular perspective of your point of view written into the legislation in the first place is critical. And that's where the issue of money and influence and all the rest of it comes into our political campaigns. So all of this is connected. And the point I'm trying to make is, is that I'm just using the Zimmerman case as an example because it's the most timely, the most appropriate one. But the issues raised by that case suggest a degree of complexity that first of all needs to be considered, and secondly needs to be considered very carefully if we are ever to begin seriously to address the issues of race in this society. I think if you look back from present back into history, depending on how fast you go and how broad your vision is, you can claim that we have come tremendous distances in overcoming some of the issues that we struggled with early on, not only in our society but in Western civilization generally. And so if you take the broadest point of view, you can say that things are getting better and better and better gradually. But the fact of the matter is some things are so explosive, some issues are so explosive and so volatile that our inability to address them creates problems for people in certain situations. It makes justice very, very difficult. I guess what I'm suggesting here in the Zimmerman case, and I guess it's probably time to bring this. It's probably time to bring this to a close, but because I think it makes the point. It leads to the issue I want to deal with, which is labor management relations in the country. But one of the things that that I think this does suggest is that we really have a long way to go. And in a popular government, in a republic like ours, we need well-meaning, good people to put their heads together and share their ideas in such a way that we can begin to address some of these issues positively. And again, some of them are so subtle. Some of them, I mean, if I had a nickel for every time I've heard since 2008 somebody say something to the effect that I absolutely detest Barack Obama, but it's not because of his race. I would love to have a nickel for every time I've heard that or something like that. And people will go to the nth degree in order to make the case that race is not the factor that causes them to be so opposed to Barack Obama. And it is so ironic if you think about it. At the very beginning of the Obama administrations, 2008, 2009, he was elected in the fall of 2008. So 2009 and 2010, if you will, during the real height of the recession. As in similar situations, you could almost predict that President Obama would be immune to a degree from criticism because of fear from critics that they would be accused in their criticism of having racial overtones. In other words, I think that there was a real concern on the part of conservatives after the election of Barack Obama that he would be a very difficult president to criticize because of the issue of race. Because it would be too easy to associate criticism with racism. And so therefore, that would cause critics to think twice before they expressed their particular criticism. But the fact of the matter is, critics of Obama, of President Obama, have made such a point over the years of denying the issue of race in the criticisms of Obama that, in a sense, as a public opinion issue, for the most part, race has been taken off the table, at least in polite conversation. And what that has resulted in is that Barack Obama has been the recipient of probably more critical commentary than any president in recent history. In other words, once the issue of race was taken off the table, it became open season on Barack Obama. And everything from the number of vacation days he takes each year to the fact that he goes to Martha's Vineyard in August for his vacations, or to Hawaii, and everything else. In other words, the criticism is endless. It seems to touch everywhere. And I thought that his administration was going to have a tremendous advantage, because people would think twice before they dared criticize it, because they wouldn't want to be accused of being racist. But now, what has happened is that so much has been made of the fact that the criticism is not race-based that people now feel very comfortable in just leveling both barrels, if you will, in their criticism. I think anybody would be naive if they believed that the issue of race is not a factor here. When you hear people say, race has nothing to do with it, he's just not my idea of who ought to be the president. Think about that. Think about that. We are at 49 minutes after the hour. Let me take this opportunity to give you the phone number once again, as well as my email address. If you'd like to send me an email, I'd be happy to respond to it on the air. That's one of the issues we're going to deal with here, is the idea that we can negotiate the chat room in such a way that if you send me an email in the midst of the program, I can respond to it right while we're on the air. I think that kind of speaks to the fact that I think some people think that I have a few more I do a little bit better at multitasking than some people believe I do, but than I believe I do. But anyway, the phone number, area code 304-658-3333. Again, 304-658-3333. My email address, I did not give this earlier, waobrien906@gmail.com. W-A-O'Brien, all one word, I-E-N, 906@gmail.com. We are, I'm sure many of you, no matter where you're listening from, you've probably seen this on various news outlets, but we here in southern West Virginia, within 20 miles of where I am sitting, we have, yesterday, the Boy Scout Jamboree opened in the new Bechtel Summit Jamboree site, just north of Beckley, West Virginia. It's about 10 miles outside downtown Beckley, north. It sits on 10,000 acres, I think 10,600 acres of land over the last 3 or 4 or 5 years that millions and millions of dollars have been put into. And so yesterday, the Boy Scouts arrived. There were, according to the news reports, as many as 700 busloads of youngsters, of Boy Scouts, who came to this area yesterday from the east, north, south, west, etc., along with families. And there are I heard a report today at our Rotary Club from one of the Boy Scout officials that there are 6,000 staff members associated with this jamboree serving these Boy Scouts. So we have families. All the hotels in the region are full. The stores, the stores are trying to keep the shelves stocked, and everybody knew that the impact was going to be tremendous on our area. This is a very rural area, southern West Virginia, but nobody really knew what the impact will be. It's going to be really interesting over the next. I believe the jamboree goes on well into next week, and so it's going to be very, very interesting when the beans are counted, so to speak, in order to get try to get the full picture on what the impact is. But it's very, very exciting in our area. The roads are a little bit more crowded than usual. There are buses everywhere. You have to wait for a table longer in restaurants, et cetera, et cetera, et cetera. It's almost like living in a city, and most people in our area are not used to that. So it's an exciting time here in our area. We are at 53 minutes after the hour, so let me take the next 6 or 7 minutes of our first hour today and kind of review and try to set up for our second hour a general discussion on the whole issue of management-labor relations in our society. And what we are talking about here is not just the relations between labor and management. We're also talking about a proper role in this relationship for government. I do want to go into some history today because I think it's revealing in a number of ways. I think it's informative. Obviously, I do because I'm a historian, and I believe that we learn from the past. And I'm also one of those people that believes if we tend to make the same mistakes over and over again, it's because we haven't learned the first time. And I believe that our relative ignorance about history and what to look for and how to use it and how to benefit from it, I think is one of the missing elements that I see our program here at the Virtual Center as addressing. Let me bring this right up to date in terms of when we talk management labor relations in the United States. This is today. This morning, an editorial in the New York Times suggested a standoff in Washington in the United States Senate between Democrats and Republicans over the filibuster. And I don't want that to be the focus of our attention. But as you know, the filibuster in the United States Senate has been, over the last several years, the way that the Republican minority in the Senate has effectively controlled Senate business. Because by regularly using the filibuster, which can only be overridden by a two-thirds vote of the Senate, that means that effectively you have to have a supermajority in order to pass anything. And as we know, in order to pass a law, this is the Constitution of the United States, in order to pass a law, it needs to pass both houses of Congress, the House of Representatives and the Senate, and then it goes to the President's desk for the President's signature. And then it becomes law. The fact that the Republicans have controlled the House of Representatives for the last couple of years, since the anti-Obama reaction of the off-year elections in 2010, the House is continually passing legislation, as we know, that cannot make it through the Senate because the Democrats control the Senate. And that control has been fairly substantial, actually, knowing that every state has 2 senators. That means that there are 100 members of the United States Senate. And so the majority in the United States Senate, we would assume, would be 51 to 49. Or 50-50, and then the Speaker, in this case the Vice President, the President of the Senate, which would be the Vice President, would cast the deciding vote if there was a tie. But the fact of the matter is the use of the filibuster has become so frequent. I don't have it ready the exact percentage, but there's no question that the filibuster has been used, 10 times more. I'm using that just generally speaking. 50 times more than it was ever used before. And the key, of course, is holding your troops together, keeping your party united. And so the ability of Senator McConnell of Kentucky, who's the President of the Senate, Republican, he is the minority leader in the Senate. His ability to hold the Republican constituent in the Senate together and to threaten the filibuster has meant that in order to pass legislation, the Democratic majority needs some defectors from the Republican ranks in order to get the 60 votes necessary to pass a particular measure by 60 to 40. So the old idea of 51 to 49 doesn't work. And this is one of the issues that I think we all need to realize and to deal with. We could say, as many people do say, why doesn't the majority in the Senate do something about this? Why don't they actually take on the issue of the filibuster? Why don't they actually make it a campaign issue to end the filibuster? The fact of the matter is, if you do your homework, it's very obvious that Harry Reid, who is the President of the Senate, he's the majority leader of the Democrats in the Senate, Harry Reid is committed to the filibuster, as is McConnell. And these guys are looking long-term rather than short-term. And their position is that at some point in time, the lay of the land is going to change. And what they do now might come back to bite them later on. So what we have is a desire to compromise in order to take on the real issue here, which is the right of filibuster. The reason I'm saying that is because this issue was on the table as of this morning. There was, in this morning's New York Times, a prospective showdown between Senate Republicans and Democrats, specifically focused on President Obama's political appointments that have been blocked. And one of them is one of the organizations is the National Labor Relations Board, the relationships, the government oversight in relations between business and labor, between employer and employee. President Obama has made a series of appointments to the National Labor Relations Board, and the Senate has blocked their consideration. And the New York Times made the point this morning that his appointments, President Obama's appointments to the National Labor Relations Board for Republicans, has become a symbol of what they believe is the Obama administration's bureaucratic overreach. The National Labor Relations Board has operated without its 5 regular members, its 5 full members, as well as with its existing appointees in limbo throughout Obama's entire presidency. So since 2009, the National Labor Relations Board has not had its full complement of 5 members. The agency, the National Labor Relations Board, is 80 years old. It's a product of the New Deal. And it has left unaddressed dozens of really hot, contentious issues between labor and management in the United States. Now comes the political perspective. Republicans have never liked the National Labor Relations Board anyway. They see it as a New Deal creation that was born in a period when government wanted to foster labor unionism. Government wanted to stimulate workers into joining unions. And that's what produced the National Labor Relations Board in the first place. Because Republicans are opposed to unions, they have traditionally been opposed to the National Labor Relations Board as a board. We might say, why are Republicans opposed to the National Labor Relations, to unions? And the most obvious answer is because union members tend to vote Democrat. Ta-da. But here's the issue, according to the New York Times, and I think this is significant. Republican anger towards unions spiked in 2011 when the National Labor Relations Board acting general counsel filed a case against Boeing. I remember this case. Boeing Aircraft, asserting that Boeing's plan to open an aircraft assembly plant in South Carolina constituted illegal retaliation against the company's workers in Washington state for repeatedly going on strike. Because the state of Washington was witnessing labor strike after labor strike against Boeing, Boeing decided to literally take its ball and go home, and to build an assembly plant in South Carolina, which is a right-to-work, anti-union state. And because Boeing did that, and because the National Labor Relations Board ruled that this was a legal retaliation against the workers of Boeing, Republicans have had it in for that board ever since 2011. And the Times makes the point that although Boeing eventually did settle the case with the board, Republicans accused it of discriminating against states in the South that were attracting investment from more heavily unionized states. This is the point that I want to make. What we see here is that in recent years, companies have tended to relocate from pro-union states, if that's an appropriate term, to anti-union states in the South, primarily because they tend to be right-to-work states. And that has been pretty much an issue over the last couple of years. Senator Lindsey Graham, Republican of South Carolina, called the National Labor Relations Board the Grim Reaper of job creation and said he would place an indefinite hold on labor board nominations to prevent it from making any major decisions. He said, quote, "The National Labor Relations Board is a four-letter word in South Carolina." And he has refused to allow a vote on any of Obama's nominations to that board since Obama became president in 2009. He says, "I understand that they need to exist," but his position is they've been kind of a rogue organization. So with Washington in the extreme partisan situation it is between Democrats and Republicans, between conservatives and liberals, it's really not surprised that Republicans, who obviously find most of their allies among business, have declared war on the National Labor Relations Board, and it's no surprise either that Democrats have taken issue with that. And this morning, the projection was that there was going to be a face-to-face confrontation, and if necessary to get these Obama appointments through, Harry Reid was threatening what was called the nuclear option, which was effectively to change the rules of the Senate in such a way that the filibuster no longer became an effective tool for the Republican minority. It is now the end of the day, and that issue came up. So I think we need to go back and revisit what happened. But first, we need to take a break. It's 8 minutes after the hour. We kind of missed the top of the hour here. I caught it. I sort of did. I was running my mouth. Let's take 4 or 5 minutes and relax and take a break and get a cold drink, and then we'll come back and continue today's version of the Virtual Center. I'm Bill O'Brien. This is the Head On Radio Network. Thank you for listening. Thank you very, very much. Thank you very much for those of you who have been with us through the first hour and are still there. I appreciate that very much. You don't know how much. That says a lot, and I appreciate that. If you've stuck it out with us, then that at least indicates that there's something worthwhile to be gained here, and that's really the whole point. If you are just joining us, we thank you. Our phone number, we would love to hear from you, area code 304-658-3333. My email address, if you'd like to send me an email, and I promise that on my own time in the morning before we come on the air tomorrow, I will do my best to respond to your email. My email address is waobrien906@gmail.com. waobrien906, all one word, @gmail.com. And again, the phone number, 304-658-3333. So for those of you who haven't been following the news today, I don't know that you would be too surprised, I wasn't, to find out that this confrontation in the United States Senate today over the filibuster didn't happen. That, you know, the Senate was able to reach a compromise in order to preserve the filibuster. I want people to reflect for a moment on that. because it kind of suggests that the ends don't even come close to matching in importance the means. The ends are the issues that the Senate, that we look to the Senate to discuss, debate, and address. Basically, the filibuster is a rule of the Senate. It is a mechanism that the Senate in the past has decided is a good thing as a key part of the way that particular branch of government chooses to do business. And what happened today was that despite the noise associated with the projected confrontation, the fact of the matter is the process won out. To be specific, a deal was reached this morning to preserve the filibuster in exchange for Senate confirmation of President Obama's long-sought first director of the Consumer Financial Protection Bureau, as well as other stalled nominees. I want to go further here because the point is important. Once that deal was made, once the agreement was made that the Senate would allow confirmation of the first director for the Consumer Financial Protection Bureau and other stalled nominations, once that decision was made, then the Senate voted 71 to 29 to begin the debate on the nomination of Richard Cordray, the acting director of the Consumer Bureau, which that debate would last up to 8 hours before the final decision was made. He would only need 51 supporters for approval. So the deal was that the Republicans would withhold the filibuster on the nomination of Cordray and allow 51 votes to nominate him in exchange for preserving the filibuster. Under the deal, struck, according to the Times, struck during late-night talks mainly between Charles Schumer of New York, Democrat, and John McCain, Republican of Arizona. Under the terms of the deal, the Senate allowed a vote on the nomination of Cordray, but put aside 2 nominations for the National Labor Relations Board, who the President appointed during a Senate recess, Richard Griffin and Sharon Block. So in a sense, and this gets to the point we were making before our break, we're looking at the National Labor Relations Board on today's program. And the issue was coming to a head over these stalled appointments. And the stalled appointments to the National Labor Relations Board was one of the key issues. But the deal was, we'll let Cordray become head of the Consumer Financial Protection Bureau. We'll postpone the debates, the issues on 2 nominees for the National Labor Relations Board, who only are there now because the President appointed them when the Senate was out of session, a so-called recession appointment. And here's the kicker. But organized labor would be allowed to recommend their replacement nominees, who would be confirmed before the end of the month. So that's the deal. The other contested nominees would all be allowed to proceed. They are the current chairman of the National Labor Relations Board, Mark Gaston Pierce, Mr. Obama's choice for Secretary of Labor, Thomas Perez, his selection for Administrator of the Environmental Protection Agency, Gina McCarthy, and the President of the Export-Import Bank, Fred Hochberg. Harry Reid, President of the Senate, Majority Leader of the Democrats, said, "I think we see a way forward that will be good for everybody. I think it's good for everybody. He said the resolution would be spelled out at the Senate's weekly lunches on Tuesday. The deal came after a 3.5-hour meeting in the old Senate chamber Monday evening, with senators saying they were confident that an agreement could be reached to defuse the tense partisan standoff. So basically, the National Labor Relations Board decision was put off today in order to allow the deal to be made. But Labor was given the opportunity to make nominations to it. I think what the issue speaks to is the fact that this issue of labor relations, this issue of management-employee relations, employer-employee relations, management labor, however you want to phrase it, is incredibly important. And the issue that we addressed last week, the issue of codetermination, which exists in many European countries, is based on a set of assumptions that do not exist within the United States today. And I think, as I mentioned in our program last Wednesday, I believe that this is the issue that we must find a way around. It is the reason I went through this today about the confrontation over the filibuster and the compromise that was reached in the Senate today. The reason I mentioned that at all is because I wanted to make clear the ideological political differences between Democrats and Republicans over the issue of organized labor on the one hand versus business on the other. The fact of the matter is it's all too simple, but it's so important. Labor tends to vote Democrat. That means that Democrats will do whatever they need to do in order to at least appear to be making concessions to labor. Republicans, on the other hand, will not hear of that. Republicans, on the other hand, will do everything that they can do because their position is that labor votes for the other side more often than not. Of course, they're right. What about this issue of codetermination as it exists in Europe, as it exists in Sweden? I want to go back to the definition of codetermination that we addressed last week in Scott's email. So let me share with you again briefly what Scott said about codetermination. He's talking about, if you remember, he was talking about Gemeinschaft and Gesellschaft and how they were very much incorporated into the whole idea of social democratic political theory in Europe, especially in Sweden. And he said, for example, one of the features of the trade union movement lying at the heart of social democracy is what the Swedes call medbestämmande, or what we call codetermination. By law, unions have representatives on boards of directors. Shop stewards have a say in company decision-making. Parents have a say in how the schools are run, etc. At all levels, participation in the decision-making process is built in and is expected of you, of citizen. Part of the responsibility of being a citizen in a political system like this is the expectation that you will participate in key decision-making. That expectation is associated, obviously, with the expectation, the idea, that the citizenry will be informed, will be educated, so that that participation will be intelligent participation. But once again, if you go even to Wikipedia and you look at codetermination, Wikipedia makes the statement In some countries like the United States of America, the workers have virtually no role in management of companies. And in some, like Germany and Sweden, we might say parenthetically, their role is more important. The first serious co-determination laws began in Germany. Basically, the idea which drives co-determination is that those people who do the job, who do the work, bring to the table an expertise, a perspective, a sense of what is necessary that has to be included in the overall decisions affecting the product or the service involved. Put the other way, the other side of that same coin, co-determination rejects the idea that only managers and supervisors have the capability of making the best decisions affecting product manufacture or service delivery. Co-determination, by definition, assumes that those who do the work know best what that work requires in order to be top quality. Opposition to co-determination rejects that assumption. There is a basic premise throughout American history that suggests, that doesn't just suggest, that clearly states that employees seek only their self-interest, never the public interest. Therefore, to bring them to the bargaining table or to the decision-making table would be counterproductive, because the only contribution they'll make is a contribution that they see as self-serving or self-interested. Their interests are their own interests, not the company's interests, not the employer's interests, not the nation's interests, not their fellow workers' interests, but their own self-interests. I would suggest to you that if you look at the history of labor management relations in the United States, you can trace the development of those assumptions in that perspective. The behavior of the people involved at any point in time would seem to confirm those assumptions as being truth, as being indeed what really is. And the fact of the matter is, not only do employers bring this assumption to the table, but more often than not, labor brings that same set of assumptions to the table. I would suggest this is the kind of analysis that we were talking about in the Zimmerman decision in our last hour, when we talk about the extent to which race did or did not play a role in that particular decision. In order to answer that question, you've got to go a lot deeper than most people are willing to go. In order to understand the major labor management relations in American society, we need to pursue it deeply. And I believe that co-determination provides us the key, gives us a wedge, gives us a way to get into this issue and really examine it in ways that it really needs to be examined in order to be really understood. It's very obvious to me, I think I said this the other day in my remarks, but they were only superficial remarks. So, I want to say this again, but with much more attention and much more clarification and clarity as to what I believe I'm saying. It is naive, in my mind, to believe that European labor management relations can accept a concept like co-determination, are willing to operate on the assumptions that everybody involved in the process has something meaningful to bring to the table. While in the United States of America that recognition is not there, has never been there, has never even been introduced there. It seems almost as if from the very beginning labor management relations in America were driven by the assumption that labor's interest and management's interests were 180-degree opposites, that the twain would never meet, and that the best we could hope for would be to somehow manage the differences between these two sets of self-interest in such a way that progress was made. The role that government has played in labor management relation through the years, especially since the New Deal, I would argue has been based on that very same premise. The differences between Democrats and Republicans over the membership on the National Labor Relations Board, the fact that Republicans recognize that union members vote Democrat, therefore they're not going to do anything to make it easy for unions to exist, let alone become stronger. And the recognition on the part of Democrats that union members tend to vote Democratic, therefore everything that we can do to support labor, or at least to appear to support labor. I say this because I'm very aware that this idea that business supports Republicans and labor supports Democrats is way too simple and much more complicated than that. It is very, very obvious, I don't care what way you look at it, that if you look at the operations and the policies and the procedures and the discussions and the activities of the Obama administration through the years of the recent recession, it's very obvious that the Democrats have not taken a hard line when it comes to Wall Street or to the bankers or to the investment houses or any place else. That the banks, the large banks and insurance companies and investment firms, Wall Street has done very well under the Obama administration, despite the efforts of Republicans to suggest otherwise. So this idea that it breaks down to Democrats, unions, Republicans, business, much too simple. It doesn't work that way, and I don't think anybody really believes it does. But what does work, what is a fact that it seems to me we can take to the bank, is that from the very beginning there has been an assumption that labor and management, employer and employee in America, are driven mostly by self-interest, and that the self-interest of one is contrary to the self-interest of the other, and that there's no meeting of the ways. There's nothing like a concept of co-determination that's even possible, because the issues that divide are so much stronger than the issues that unite. What I am about to and am setting out, the reason I'm addressing this issue is because, A, I believe it's one of the most important issues in America today. I believe it really is at the heart of whether, in fact, we recover from the recession and how far we recover from the recession. I think the issues will affect us in terms of jobs and job creation and all the rest of it are driven by this issue. So I think it's incredibly important. The second thing, which I think is even more important, I think that our relations between management and labor in this country are driven by stereotype and are driven by a past which we need to understand and we need to recognize and we need to address. Because C, I think the third issue here is the most critical of all. In the world of the 21st century, the ability of the American economy to compete successfully in all areas, not just manufacturing, not just agriculture, not just service delivery, not just health care, not just education, in all areas, our ability to compete successfully is going to depend more than it ever has before on our ability to overcome some of the assumptions that have driven us up to this point. Some of the assumptions that we have taken for granted and have never examined. And I think relations between management and labor is one of the most important. I think in education, I think, for example, for many years I was a faculty. I always consider myself a faculty member. I've always believed that governance in higher education is something unique. I believe that what has made American higher education first in the world for so long has been its ability to make wise decisions. And that ability has been in large part because higher education has adopted or has operated according to a set of principles associated with the idea of what is referred to as academic governance. A recognition that quality decisions can only be made when everybody who has something positive to contribute to those decisions is at the table and is consulted. In other words, our strength is on our willingness to be inclusive, not exclusive. And one of the major failures in labor management relations historically in the United States has been its exclusivity at various levels. Not only management's unwillingness to work cooperatively and positively with labor, but labor's unwillingness to work positively and cooperatively with itself, with its own constituents. Over the years, and I'm just making general statements here at this point, but we have witnessed a labor movement in this country that over the last 150 to 200 years has seen its best interests in excluding immigrants, excluding the unskilled, excluding women, excluding gays, excluding minorities, racial minorities, excluding Catholics. We have seen the history of a labor movement in this country that has been driven largely by how to get a bigger piece of the pie. And oftentimes, the strategy for making that happen is to take positions which work contrary to those who have more in common with you than they do in opposition to you. One of the terms that is ripe throughout labor history, it seems to me, you see it all the time, is reference to the term company union. And what I mean is those times when leadership in unions has set about working with employers as opposed to theoretically representing the best interest of employers against the company. The assumption is the self-interests are contradictory. And the assumption is that the job of the union representative is to represent the workers in the best interest, the self-interest of the workers against the company. Whenever it appeared that union officials were becoming too cozy with management, the term company union or sellout came into play. There is absolutely no question in my mind that the history of labor management relations in the United States is rich in the number of examples of a divide and conquer strategy which has made it impossible for working people ever to legitimately organize in the society with the idea that as working people they have something positive to bring to the table in terms of decision making. But it goes deeper than that. You don't see much evidences of that. But you don't even see evidences of willingness to try that within working people, among working people themselves. Working people themselves are the best examples of the stereotype, of the assumptions which drive the process. I mentioned earlier that the history of labor in this country is the story of one exclusion after another exclusion after another exclusion. And so the question is, what is it that drives this tendency to want to be exclusive? And I would suggest that employers have a significant role usually to play in that, because it is to the interest of employers to create discord and diversity within the labor force. If I am an employer and I employ two groups of people, it doesn't matter what they are, skilled, unskilled, it doesn't matter what they are. Let's just call them A and B. If, as an employer, I have got to deal with representatives of A and B, I am in a much stronger position if I can somehow make it difficult for A and B to work together. If I can deal with them separately, chances are I'm going to prevail. The way to do that, oftentimes, is to work with A and make it clear to A that there's more to be gained by working with you than by working with B. And the fact of the matter is, if there are very positive results of that assumption, in other words, this is not just rhetoric we're talking about. If A is able to secure significant contractual benefits from the employer, then the members of A begin to recognize that their best interests are to not work cooperatively with B. And so, in a sense, A and B are pitted against each other for reasons which may be legitimate. There may be real differences between A and B. One group may be skilled, the other group may be unskilled. But the fact of the matter is, all of it is driven by the absence of a recognition that A and B, A or B, whatever group you take, it is all driven by the assumption that they don't have anything positive to bring to the table. Your job is to negotiate with them and to find a way to contractually get the work done for the least possible amount of salary. That's what the name of the game is. Getting the job done for the cheapest amount. It's salaries that drove, it's that drives Boeing to South Carolina. It's lower salaries that drove union firms to the South, where they could become non-union firms. It's that same assumption that is driving firms outside the borders of the United States totally, because the salaries are even less. It used to be that a move from north to south was enough. Now, the profit to be made by reducing salaries by locating overseas in other parts of the world where labor costs and expectations are much less makes the company, in its eyes, makes the company much more competitive, because it is required to pay out less in labor and benefits to its employees. And so, in answering to its stockholders, the less generous you can be to your employees, the more value there is to your stock, the higher the dividends to the stockholders, etc., etc., etc. All of these considerations are very important. The only thing that I wanted to try to get across today, and I want to really pursue this tomorrow with some background and some history, is the basis, the assumptions on which this whole idea of codetermination can work or cannot work. I spoke to one of my closest friends, who's a very, very strong advocate of organized labor. Generally, I mean, that his sympathies, his sentiments are on that side. And I asked him about codetermination, and specifically if he knew what it was, and he did. And I said basically, well, what I need to pursue, and he said, well, it can't work in America, can't work in the United States. There's no sense even talking about it. It just can't work here. And I said, why? And he said, because there's too much animosity, too much distrust between employer and employee, between labor and management in the United States. And so the question that we are left with, the question that I bring to you, is why is it that labor management cooperation, co-determination, can work in some countries, but not in this one? Is it something in the air? Is there something about coming across the ocean that changes one's genetic makeup to the point that what'll work in one place can't work in another? Or is it the environment? Is it the context within which labor management relations in this country are asked to work together? Is the history of labor management relations in this country not just the history of it, but is it in fact the creation of a context, of a reality that everybody who's involved today assumes has always been there and always must be there and cannot be changed? Are we operating in an environment where what is possible and what is not possible are decisions that have already been made and have led to a series of stereotypes and a series of assumptions which cause people to believe that change like that can never happen? It comes very, very close in my mind to the idea we talked about the other day of inevitability. We were talking about war, and at what point we talked about the Civil War specifically. At what point did the Civil War become inevitable? And if you take on that question, and if you accept the concept of the idea of inevitability, then what you are saying is there comes a point beyond which man is no longer in control of what he does. Circumstances, environment, whatever, history, take over. And man becomes merely an actor in a play that has already been written and whose conclusion has already been written. And that conclusion is war. Shakespeare made the very famous statement that life is merely a stage, and we are just mere players on that stage. Is that true? To what extent do the players control the play? To what extent should they be able to control the play? To what extent ought the players have the right to design an alternative ending to the play? It is my belief, in years of reflecting on this, and I don't put myself ahead of anybody else in this. This is just me talking. But as I think back to, I'm enamored. I'm incredibly impressed with Tom Friedman's book, The World is Flat, and everything that has followed from that. I really do believe that we are entering into an age. We are in an age, not are entering. We are there in the 21st century, in which America, the United States of America, no longer has the manufacturing and educational advantage over the rest of the world that it has had throughout much of its history. I believe our success is going to be determined by our ability to really compete. We've never had to compete before. We've played lip service to competition and how much we respect competition, but always we believed that we would always prevail in that competition. We could not lose. For years, we believed that our Olympic basketball team had to be the best in the world and not never to lose. In our foreign policy, I'm using this as an example, we talked about this in a previous program. In our foreign policy, we began to adopt foreign policy priorities which were pretty much defined by and explained by the open door policy created at the end of the 19th century as it applied to the Far East, principally China. And the idea of the open door is that there were certain principles of economic development that we wanted all competitive nations to buy into. The idea of open seas and free trade and free competition. We believed firmly, we believed 100% in the process. And we believed that the more countries we could get to buy into the process, to buy into the idea of open trade, free trade, no tariff barriers, no restrictions, no limitations. Everybody had a chance to play the game and play the game with whatever they had. We believed that in that kind of a world, we would always dominate. We believed that we had the manufacturing and educational capabilities necessary and the political support system to make the theories of free enterprise operative in the world. And we believed that if those theories and assumptions were operative, we would always prevail. If indeed you accept the premises of those assumptions, if we are to prevail today in a world that has become flat, according to Tom Friedman, which means that no longer do we have the technological and educational and political and natural resource advantages that we had throughout the 20th century. That means that the only way that we are going to continue to prevail is to really be able to effectively compete. And in order to do that, in order to effectively compete, we have got to overcome one of the greatest obstacles that stands in our way now. And that is our idea, our assumption, that before we can take on competition, we have to basically eliminate or exclude those who are not up to the competition. We have never believed as a nation that everybody can be educated. We pay lip service to the idea that everybody, every human being is unique and every human being has something positive to contribute. But we really don't believe that. We have never found a way to bring that into fruition, to make that real. What we have chosen to do is exclude, exclude, exclude. If this is going to work the way we want it to work, then we can't allow this particular group to participate. If our test scores are going to go up, then we have to make sure that a certain group of people is not there to take the test on test day. If we can eliminate them, then we have a chance of our test scores being competitive. If we, as Boy Scouts, are going to have a successful jamboree, then we've got to exclude obese kids. And we do that. It's 59 minutes after the hour, and I am the mouthiest person today. I'd love to have you join us tomorrow for another session of the Virtual Center. I'm Bill O'Brien. Thank you for tuning in. Thank you for listening to the Head On Radio Network. Stay tuned for Bob Kincaid's program. I'm Bill O'Brien. Back together again with you tomorrow. Please be safe.